Houston Real Estate Radio starts right now.
Welcome back. You're listening to Houston Real Estate Radio. I'm your host, Shannon Register, and we have a call-in number for you if you have any real estate questions, 281-882-8088. You can find us online at HoustonRealEstateRadio.com. And this segment of today's show is being sponsored by The Perfect Light. You can go online and find them under theperfectlight.com, and they can help you with all of your landscape lighting needs and also mosquito misting systems, which is a great thing because I was out over the weekend with all this rain and the mosquitoes are out. So that's a great thing to have. I am joined here in the studio today with Bryan Abercrombie. He's from Cordell, a law firm in Houston. And we want to talk a little bit about some things that he is very familiar with, and that is some family law that has to do with real estate. Because, you know, there are so many different issues that can come up when you have divorce or when you're getting married and there's real estate involved. And even when you have real estate and you're planning for the future and trying to plan out your will. So welcome to the show, Bryan.
Good morning.
So glad to have you here. A lot of interesting things to talk about. One of the things that's interesting in Texas is everything is considered community property once you're married. Is that right?
That's correct. Texas has what's called a community property presumption. So when spouses marry, any property that's acquired during the marriage is presumed to be community property. Now, there are some exceptions to that, but for the most part, everything is considered community property. The exceptions are pretty simple. It's stuff that you owned prior to marriage would be separate property. Anything by gift or inheritance, or anything that the two spouses put in writing and said they wanted to be separate property would be separate property.
Now, the thing about owning stuff before marriage, it does get a little bit messy, though, if both of you live in the house as your primary residence after marriage, right?
That's correct.
That kind of muddies the water a little bit?
Yeah, it sure does. If someone owns a house before they get married, that would be their separate property house. However, when you get married, everything becomes community property. That includes, your salary or probably what you're using to pay that mortgage payment every month. And so if there's a divorce later on down the road, then the spouse, while they may not have title to own the house because it was purchased before marriage, they would have a claim going back against the house for reimbursement for reduction of principal, different things that might have been improvements on the house that might have enhanced the value. There might be some reimbursement claims that the spouse might have back, or the community estate would have back, for the enhancement of that separate property house.
And if someone wanted to, let's say someone's out there thinking about getting married and they've got a messy, what I call a messy marriage, which is they've got children and they're going on a second marriage and there's a lot of land involved and that sort of thing. What's an easy way to clean all of that up? We all hear the term a prenuptial agreement. How does that work in Texas?
Well, Texas has basically a prenuptial agreement. It's called a premarital agreement. Spouses can agree, prior to marriage, they can contractually agree what's going to be considered separate property, what's going to be considered community property, and with a lot of blended families nowadays, I think it's very good. A lot more people are doing premarital agreements just to kind of protect and preserve assets, because a lot more people are going into marriages with significant property, retirement accounts, various things, and real estate being a big part, and stuff that they would want to leave to their children, and so premarital agreements are very common nowadays. It requires, both parties to agree, and both parties can put their disclosure of property in there, and then they can contractually agree as to what's going to be separate property and what it would be going forward.
And if you're already in that marriage and you're thinking, wow, we didn't really think ahead on this, we might need to figure out what's going to happen next. Is there anything you can put in place at that point, or is it too late once you're married? No,
once you're married, Texas allows for two spouses to agree in writing that certain property would be separate property. So spouses are free to do what's called in Texas, they call it a partition and exchange agreement, but it's basically a marital property agreement where two spouses can agree that okay, this property or this account or whatever it is going to be separate property. It just has to be done in writing and has to be signed by both spouses.
Okay. All right. Now, let me give you an example of something that I'm seeing recently. I've got a lot of married couples, happily married, who are purchasing investment property because we've been in a great market for buying investment property. What I'm finding, though, is that once they buy several investment properties, maybe her income isn't enough anymore to support it, and so they're not wanting, because she's not on the loan, they don't want her signing the paperwork at the title company and don't want her on the deed. Does that affect her right to the community property in that situation?
Not in that situation. If two spouses are acquiring property during a marriage, and like I said, it's not done with any kind of property agreement, or it's not done through any kind of separate funds, then no, that wouldn't affect it. I mean, there's a lot of situations that come up where, one person has great credit, one person doesn't have great credit. So that, mortgage companies don't really want this person on the paperwork.
Right.
And so, but it doesn't change the community property character of the property just because it's financed or titled in one person's name over the other.
Okay. And so, and a lot of stay-at-home moms, they don't have any income, so the lender doesn't want them on the title as well.
Definitely. Yeah,
so
that happens quite a bit. And like I said, and that's probably why the law is in place the way that it is, because yes, you're absolutely right. Stay-at-home moms wouldn't have any income, so to a lender it wouldn't necessarily be as attractive as someone who has a steady income. But it's just the same. Their property,
right? So equally shared property.
Correct.
So when they go to sell that investment property, since only one spouse was on the title and one spouse was on the loan, when they go to sell it, can that one spouse only sign for it, or do they both have to sign for it?
It's probably just going to be just the one spouse having to sign for it. So normally that's the way they would do it. But title companies are different. I mean, sometimes they may want to get the other spouse to sign, although I don't know what they'd necessarily be signing, but just to be on the safe side. But for the most part, it'll probably be just the spouse whose property's titled. And in a marriage, spouses can manage certain property, and they have what's called I guess managed community property. So they're basically managing a community asset, which is if it's titled in their name, that's probably what it would be.
So I think the main thing is, as long as any property, whether it's your personal residence or investment properties, whatever the property may be, a second home, as long as it's purchased with a person's name, you're pretty much it's community property. If it's purchased as an entity or a trust or a separate property, then it can be one or the other. Is that right?
Right. If it's purchased through a trust or through a corporation, then it wouldn't necessarily be community property at that point. I mean, I think it would probably depend on what the trust document
says, how all that was set up,
or the corporation or the partnership or whatever purchased the property may be a community asset. But yeah, if it's purchased through an entity, it wouldn't necessarily be marital property at that point. But like I said, a lot would depend on how a particular entity was set up or what it was purchased through. But just in general, I mean, the law tries to make it easy and say everything's community property. So there's a burden in Texas that requires a person, if they're going to show that it's separate property, the burden is on them to prove it.
Okay, that's interesting. The burden is on theirs to prove it. Interesting. Okay, so for example, because I've recently had this happen, had a single woman who owned a home. She had lived in it, but she turned it into a rental property. She got married, but once she was married, they never lived in the home, so it continued to be her investment property. And then she sold it, and the title company still wanted him to sign something, and I'm not real clear what that was they wanted him to sign, but they wanted him to sign something, even though he had never lived in the property and was not receiving any benefit really from it. What do you think about that?
That's interesting. I wouldn't know what they would have him sign. That's interesting. Maybe they were just trying to cover bases. If she was using it as rental property, then the rents received on a piece of separate property would be community property.
Right.
But the actual title to the property and the character of the property would still be separate property. Maybe they were just trying to make sure that they were doubly covered and there wouldn't be a question later. But.
Well, and that's what I find with title companies. That's what it seems like they're doing, is they're over worrying about themselves more than they are the property owner and the way the law reads about it, because they want to make sure that no lawsuits come back on them, obviously.
And a lot of times they'll want some sort of a release just in case, kind of I would think to kind of probably insure themselves. that there's not some kind of sneaky things going on or whatever. But normally it's if you have a piece of separate property, you can do what you want with it. But
okay, now here's kind of the flip side of that. If she owned the property and then they got married and he moved into the property, so now it's their home that they're both living in, and then they get a divorce. Now is that his property as much as it is hers?
No. The character of the property was acquired. It was separate property. So if they get divorced later, then it would still be separate property. However, he might have a claim back against the property or against her estate for enhancements to the property. If the property increased in value, if they paid down the note and there was a reduction in principal on the note, he might have some, or the community estate might have some claim towards to that separate property for reimbursement, but the actual title to the property would still be in that spouse's name. And
he may be the one repainting it and
he may be doing a lot of work
taking care of it. So hopefully you'll get some benefit back out of it, right?
Yeah, and the reimbursement claims, you have to prove the claim, but if you can show that you enhanced the value, or reduction in principal is pretty easy because you can show, okay, we made X number of payments over X number of years, and we owed this much and now we owe this much. So that's oftentimes real easy to make. But yeah, if there's things done, a new deck was put in, or
sweat equity,
right, new hardwood flooring or something's put in the house that really enhanced the value, then yes, the spouse would be entitled to make a claim for at least half of the value that was created.
All right, some good information we're getting from Bryan Abercrombie with Cordell and Cordell. He is an attorney here in town, and we're going to come back in just a few minutes after a word from our sponsors and talk about a couple other things that we didn't have time to get to. So hang on, Bryan. We'll be right back. And if you're listening to Houston Real Estate Radio and you've missed any of today's show, you can go to HoustonRealEstateRadio.com, where we have videos of all of the shows, so you can catch up on any of today's show that you missed. We'll be right back.
Thank you.